All right, defense, you may proceed.
Your Honor, ladies and gentlemen, at this time, the defense will rest.
Okay. State, any rebuttal?
No, Your Honor. Ladies and gentlemen, the jury, this time the state will close. Defense closed, Your Honor.
All right. So jurors, it is now time for us to go over the charge with you. That means that all the evidence and testimony that you will receive in punishment, you have now already heard. We will move to the jury charge on punishment. Members of the jury, the defendant, Datrell Dion Clayton, has been found guilty by you of the offense of murder. The court has received and accepted your verdict of guilty, and you will no longer concern yourself with the innocence or guilt of the defendant, and shall now limit your deliberations under all law and evidence in this case to the question of punishment, which is now your duty to assess. The punishment authorized for murder is imprisonment in the institutional division of the Texas Department of Criminal Justice for life, or for a term of not more than 99 years or less than 15 years. And in addition, a fine may be assessed not to exceed $10,000. Prior final felony conviction. In addition to the first paragraph of the indictment further alleges in an enhancing paragraph the defendant has previously been convicted of a felony offense. The defendant has entered a plea of true to this allegation. Said enhancing paragraph alleges that prior to the commission of the offense of which you have found the defendant guilty, the defendant was found guilty of the offense of aggravated assault with a deadly weapon in the Criminal District Court, number 6 of Dallas County, in cause number F1571973 on the 24th day of October, AD 2017, and said conviction was a final conviction and was a conviction for an offense committed prior to the commission of the offense of which you have found the defendant guilty. Because the defendant has entered a plea of true to the enhancing paragraph, you are bound to find the enhancing paragraph to be true and shall so enter on your verdict form. Parole. The length of time for which a defendant is in prison may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law and good conduct time might be applied to this defendant if sentenced to a term of imprisonment, because the application of these laws will depend on decisions made by prison and parole authorities. You may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant. You are not to consider the manner in which the parole law may be applied to this particular defendant. Defendant's election not to testify. Our law provides that the defendant may testify in his own behalf if he elects to do so. This, however, is a privilege accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as circumstance against him. In this case, the defendant has elected not to testify in the punishment phase, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations, or take it into consideration for any purpose whatsoever as a circumstance against the defendant. Burden in proving extraneous acts. You may consider evidence of an extraneous crime or bad act in assessing punishment, even if the defendant has not been charged with or finally convicted of the crime or act. However, you may consider such evidence only if the extraneous crime or bad act has been shown by the state beyond a reasonable doubt to have been committed by the defendant, or as one for which the defendant could be held criminally responsible. The state does not have to prove an extraneous crime or bad act beyond all possible doubt. The state's proof must exclude all reasonable doubt concerning the extraneous crime or bad act. Therefore, if you find and believe beyond a reasonable doubt that the defendant committed an extraneous crime or bad act, or could be held criminally responsible for an extraneous crime or bad act, then you may consider such evidence in assessing the defendant's punishment. However, if you have a reasonable doubt that the defendant committed an extraneous crime or bad act, or could be held criminally responsible for an extraneous crime or bad act, then you may not consider such evidence in assessing punishment. Concluding instructions. You are instructed that in assessing the defendant's punishment, you may take into consideration all of the facts and evidence admitted before you in the full trial of this case, and the law as submitted to you in this charge and the charge hereto given to you by the court. The jury is only permitted to receive evidence regarding the case from the witness stand. During your deliberations, you are not to consider, refer to, or discuss any matters or issues not in evidence before you. You should not consider or mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You may not use an electronic means or device to communicate about or research the issues, facts, or law in this case. You should neither consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You are not to talk about this case to anyone who is not a member of your jury. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive and to follow the law from the court. After you have retired to consider punishment, no one has the authority to communicate with you except the bailiff who has you in charge. You may communicate with the court in writing, signed by your presiding juror, through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any question you may have. After argument of counsel, you are retired to the jury room. It is the presiding juror's duty to preside at your deliberations and to vote with you in arriving at a verdict. Your verdict must be unanimous. And after you have arrived at your verdict, use the verdict form by having your presiding juror write your verdict and sign the verdict form. After you have reached a unanimous verdict, or if you desire to communicate with the court, please use the jury call button on the wall and the bailiff will respond. Signed by Judge Leila Lawrence Mays, presiding judge of the 283rd District Court. The last form is the verdict form for punishment, and it reads, "We, the jury, having found defendant Datrell Dion Clayton guilty of murder, and further having found the allegation set in the enhancing paragraph is true, assess the defendant's punishment as imprisonment in the institutional division of the Texas Department of Criminal Justice, a term of blank, which is either life or it's a blank for a number, 15 to 99 years, and a fine of," and below it says none or not to exceed $10,000, and you could fill that in. That will be signed by the presiding juror and then the printed name of the presiding juror. That concludes the court's instructions. Counsel, are you ready to proceed with closing?
Thanks, Your Honor.
All right, you may proceed.
May it please the court?
Yes.
Permission to move about the well, Your Honor?
Pardon me?
Permission to move about the well?
Yes.
Thank you. I am what I remain. What I am not, I will not try to be. Those were his words. Super savage. Super savage. Datrell Clayton. This man has had chance after chance after chance after chance and after chance again. He's not changed not one bit. Don't fall for it. Every single time you heard those findings yesterday, what did you hear? The public is in need of protection. The public is in need of protection. The public is in need of protection. Now, ladies and gentlemen, you've heard the old saying that there's a time and a place for everything. A time for which there's a purpose. Now, ladies and gentlemen, it's your time. What say you? You've heard all week from members of this community whose lives have been ruined by this man. King Morgan, Jeremiah Gray, Michael Dukes. You even heard the screams of Malik's mother, who begged God on that 911 call to take her life and not her baby's life. But you know what? I'm tired of talking about him. This is who I want to talk about. Today's Exhibit 1. The little boy who wore green on the day he died. The little boy who danced before he died. The little boy who cracked jokes before he died. I want you to remember him. This is what this is about. This is about Malik. This is about our community. This is about the beautiful patchwork quilt of lives who are forever ruined by the hands of that man. I want you to think about this sweet boy who will never get to go to prom. He will never get to cry. He will never get to play basketball again. He will never get to feel the sun on his face. He will never get to walk down the aisle. His parents will never get to tuck him into bed at night. He will never get to have a chance at life. This is who I want you to remember today. This is who we remember today. Malik's life mattered. It was cut short, and it shouldn't have been. And now, we talked to you before, you've heard that this is every mother's nightmare. And what he wants you to do, he wants you to give him one more chance to roam the streets of Dallas yet again. Do you want to take that chance? Do you trust him? How about you? Ladies and gentlemen, it is your time. It is your time to send a message to the community. What say you? What say you for Malik? What say you for homicide detective Barnes? You don't see that in the movies about homicide detectives who give you their personal number in case you need help. And what do you see happen? Less than 1 month later, now an innocent child's life has been snatched away forever. Oh no, we can't let that happen here, ladies and gentlemen. We cannot continue to see this community ruined. Lives changed forever. A trail of tears that will never go away. You saw it, you heard it, you felt it. Should we allow this man to go back on the streets of Dallas like a bad dream that never goes away? I think not. We trust you. We know you'll make the right decision. We want you to remember and never forget the little baby in green. State's Exhibit 1. The reason why you're here. It's no coincidence that all of your lives have come together for such a time as this. And we trust you to make the right decision for Malik, for his family, for our community, for the state of Texas, for all of you. Do you trust him? Do you trust him? Thank you.
Thank you.
May it please the court.
Yes.
Counsel. Ladies and gentlemen of the jury. Again, I'd like to thank you for all the time and attention we've taken out of your lives over the last part of the last 2 weeks. I know it's been very taxing on you. I want to tell y'all that one of the things, the way we selected this jury in this case was it's a very unusual process where we bring everybody down there in that big room. It's odd because I didn't really feel like we had an opportunity to get to know you guys individually. Typically, we pick a jury, everybody's sitting in this small space here, and we pick a jury right here, but we have a chance to look in everybody's eyes while we're talking. A lot of you on the jury I don't even remember seeing in that huge room because it's so spread out and there's so many people in there. So it's a little odd as we stand here because we had a lot more of an opportunity to have direct contact with you and ask each one of you some questions. So as I said in the closing argument at the punishment phase, we do believe, both sides believe, that we picked a fair jury. We believe we've got a group of people here, the people that said they had problems, raised their hands, we got rid of those folks. You people said that you understood the process and you understood what the issues were going into this case. Obviously, you've ruled against us on the issue of guilt, and I respect that. As I've told each one of the witnesses, we're not here to argue with or to try to disagree or disparage that verdict in any way. You had a tough job to do, and I thank you for doing it, okay? But the job is only halfway finished now. The job's halfway finished. And I was a little bit amazed when the state of Texas got up in the opening statement regarding punishment, and said that they expected that when they're finished, they're going to come before you and ask you to sentence the defendant in this case, 24-year-old Datrell Clayton, to life in prison. Because, ladies and gentlemen, let me ask you a question. What is life in prison? What is that designed? What is that reserved for? Okay, that means it is the worst of the worst of the individuals you could ever encounter, the worst of the crimes, where people go out. And if you sit back and you think about the things you hear about that take place in our society, and you hear about the types of individuals who wake up on a daily basis and make decisions to go out and victimize members of our community, the depravity that these people have in their decision-making process and the crimes that they commit, those are the kind of people that the state of Texas is usually down here asking for a life sentence on. Because, folks, I'm going to go back to what I told you in the closing on guilt. I honestly don't see how anybody can sit there and look at this as anything but the tragedy that it is. It's a tragedy. Datrell Clayton didn't go up there that day with any intention to victimize anybody. And that's what we're talking about here, is when you decide what's the appropriate punishment, and I asked you in Board Hour, does everybody agree that a person should be punished for that which he intended? And I told you that this indictment was going to say he had an intention to kill Malik Tyler, that he was knowingly trying to cause him serious bodily injury. I told you that if the state could prove that to you, then find him guilty. Okay? Now, this charge was very difficult. The law in this case is difficult because of the facts. You do not see these kinds of facts very often, folks. Very, very seldom do you ever see anything approaching the legal issues that we have here. And that's why this trial was so contentious. That's why y'all were bouncing in and out of the room.
Your Honor, I'm going to object to improper argument and arguing outside the record.
Ladies and gentlemen, the bottom line here is you have done part of your job. And now you have to go back here. You are going to have to go back here and make a tough decision. And I don't, like I said, I don't know. The state's going to come in here and say, well, we proved to you that the defendant has a criminal record. He had a juvenile record. The prosecutor says, oh, look at the box check. We have to protect the public. Well, if you go back and look at it, you've got the paperwork. They have a few boxes on there. You have to check. That box has to be checked in order to take someone through the juvenile system. Go back and look at it. It's not some kind of a big finding that they made that he was all that dangerous.
Your Honor, again, I'm going to object to facts not evidence.
They're arguing the other side of it, Judge.
Excuse me just a minute, Mr. Johnson. Jurors, you all remember the evidence that's before you. Thank you.
They want to argue that checking that box, it means something that, you go back and look at it, it doesn't really mean. Bottom line here, folks, this is a tragedy. This is a tragedy. What do we know about Datrell Clayton? Well, folks, we know he's had a tough life. We know he's had a tough life. And, you know, I asked his sister yesterday, because she said, yeah, and she's done well for herself, no question. She's pulled herself up. She's done very well for herself. And prosecutor said, well, you had a pretty good childhood, didn't you? And I submit to you that if you heard the life that they had, mom in and out of the life, the aunt coming in and having to adopt the kids so she could take care of them and raise them, and then mom comes back into the picture a few years later and says, I want to take the kids back with me again, and she takes them over, and several months later, that's when these issues started happening. But what else do we know about Datrell that was behind this? Well, we know he was a young man that had, as his family testified, he had a little bit of an otter look to him when he was younger, had bad teeth. He had issues, ADHD, he was diagnosed bipolar, he was in special education, and he was bullied. He was bullied. hear from listening to his sister how it affected her to have to witness Day Trail being bullied. And folks, what happens when people are being bullied? What happens when people are being victimized? I submit to you it's logical and it's reasonable that they seek out other folks. And all the stuff about the gangs, folks, I'm not here to argue. I mean, the state put up all this stuff but I submit to you that what we got is a situation where the defendant is on the videotapes, running around, jumping around, singing, doing a bunch of stupid stuff. Are you really gonna put someone in prison for what's on that videotape, on a rap song? They brought his criminal record. He was never sentenced to TYC as a juvenile. He had some placements, never even put in what they call the TYC prison. And as an adult, they brought to you his criminal history, and they told you that he had 3 cases. He was sentenced at one time on all those. As you heard from his family, there was issues in that case about who the aggressor was. Whether or not the assaults were the result of him being forced to defend himself again. But what do we know? What do we know? Okay, if it was that serious of a situation where he had been out victimizing, just straight out wanting to victimize people, do you really think the state of Texas would have pled him to 2 years? Or would they have been out yelling that they needed 20 years, the maximum, which they're saying they need in this case? He got the absolute minimum sentence you could get. They made the point of bringing that out. The absolute minimum. They gave it to him. This prosecutor, remember he made a big point of talking about how we all got together. They decided that case was worth the minimum sentence. And now they're going to say that what happened out there on this particular day, put into motion by no fault of his. They're telling you now he's graduated to a sentence of life. And we know that the real person that was out there with the intent to victimize is looking at most 20 years. That's all he's looking at. Would it be not a tragedy to know that the person that put this into play can't get more than 20, but they're asking you to give him life? I submit to you folks, that's an absurd result. This is a tragedy. The prosecutor says, well, he made efforts, or that he had the opportunity to try to change when he got out of prison. Well, what did you hear from his family? Okay? And go back and think about it, because when the detective was talking, when Jabari and Barnes were talking, they said that this little clique of gang folks, his running buddies, they said that they had broken that up, put them all in prison. So they're out of the picture. So we got Day Trail Clayton, he does his sentence down there, he does that 2-year sentence, and he gets out, and what does he do? He talks to Barnes. You think Barnes is out helping people that he thinks is the worst of the worst? Come on, folks, no. Barnes has a conversation with him, call me, I'll do what I can to help you. But we know that the defendant's going out, he's gotten the job. He's got the job. You heard his family talking about how they have to get up in the morning and lug him back and forth. What else do we know about the defendant? We know the kind of person he has always been around people that he knows. Very loving. Very loving. We brought in 6 or 7 people to talk to you about the defendant. And as you know, they told you there's several others out in the hallway. I'm not going to sit there and put the same people on over and over to say the same exact words. But it gives you an insight into the defendant. It gives you an insight into his heart. And what did they tell you? Got a 6-year-old son. 6-year-old son. They talked to you about how he loves kids, how he has been devastated by his involvement in this situation. And you know, folks, back in the day when they used to execute people by firing squad,
I'm going to object to improper and relevance.
Judge, I'll tie it up and it won't be improper.
Go ahead.
I submit to you folks, when they used to have a firing squad, they bring 4 or 5 people out there, they give them all a gun, and one of those people's guns had a blank in it. One of those people's guns had a blank. And why did they do that? Because even though you partook in that execution, you could always hope that you were the one who had the blank. I argued that we don't know beyond a reasonable doubt if it was the defendant's bullet that killed Malik, because we don't have definitive proof. And if it was, you found that it was, I'm not here to argue with it, but I submit to you that there's some solace in at least a person like him who loves kids. His family told you he used to be up there at the store and the kids, he would give them money to buy candy and things. It told you about how a loving person that he is. I submit to you that it provides some solace that he can lay down at night hoping that maybe it wasn't his bullet. But the question is what are you going to do? And as I said, folks, I submit to you, because of that 2-year sentence, because he had received the minimum sentence before, they're now going to ask you for the maximum. And I think that it's ridiculous. I'm going to ask you not to sentence him to anything more than the 20 years that Tyler Buchanan is facing. I think it's just an absurd result to think that the defendant in this case would get more than the instigator, the one that came out there with a bad heart.
3 minutes remaining.
Daytrail had in fact tried to turn his life around. He had turned his life around. He had done, there's no evidence that, I mean, they brought up that he had gotten an evading arrest a month or so before, he'd gotten out, but he was still working. He was doing those things. As I said when I questioned the witnesses, he may not have been living the perfect life, but he wasn't out there victimizing people. There's no evidence of that. He got him a job, he was doing the things he was supposed to do, he was taking care of his family. Folks, go back here and when you talk about it, get together and say, folks, and y'all make a decision whether there was something in his heart that was blackened by the desire to make people victims. Everybody's heart goes out to Malik Tyler and his family, no question. No question. But folks, going back there and trying to make some kind of statement that when somebody's shooting at you, and go back there now, because we talked in board hours about the shoes of the defendant, putting yourself into the shoes of the defendant, how you view things from that standpoint. I hope that the fact now that you know that he'd been the victim of drive-by shootings in the past, where he'd been hit by the same type of activity Tyler Buchanan engaged in that day, because that apparently is what people do in order to show their disagreement or dislike for others, is they drive by and indiscriminately shoot. Go back there and think of how that might have affected his mind. He's sitting there that day, and as you know now, he's in there with a friend of his, and they're in that friend's child. And as these bullets start to rain down upon him, you don't think that was what his thought was? The prior times that this had happened to him? That's a factor that you can consider. That's something that you can consider. I'm going to tell you guys something. You're not a juror on murder cases. You don't see the things that go on down here all the time. You saw in this courtroom the family of a person who's not perfect, but who is loved and who loves. The kind of person that has a heart with empathy. They've told you how he is devastated by the death of Malik Tyler. Let's don't make this into a second tragedy or a third tragedy. We're going to have a young man out here, his son, that needs his father. You know that the law tells you on the parole that whatever you do, he's got to serve a minimum of half of it. I'm going to ask that you go back there, and folks, I'm going to ask that you assess punishment somewhere around between 15 and 20 years. And think about it, 15 and 20 years. Where were you 20 years ago? Where were you 20 years ago? I submit after Daytrail went to prison before, he learned, he changed. And now he's going to have to do time for something that was a tragedy. I'm going to ask for a sentence that's justice. Justice but tempered with mercy. And I believe that would be in a sentence of no greater than 20 years. Thank you.
Thank you. Mr. Adams?
Thank you, Your Honor. May it please the court?
Yes.
Ladies and gentlemen.
I want to be very clear. This man is not the victim. This man, who you said you could consider the full range of 5 to 99 or life, if we brought you the right case after finding him guilty of murder, is not the victim. Defense counsel, and I'm just going to respond briefly to what he discussed, was that a life sentence, I want this to resonate with you, a life sentence is for someone who is waking up and victimizing the members of our community. That's who a life sentence is intended for. Those who commit the worst of the worst. And all afternoon yesterday, we heard about this man being the victim, and not one. But because of what this man did, and what he should have known better, because of the opportunities that he'd been provided, because of the chances he'd been given over and over and over. 12 years of chances through the criminal justice system. A loving family. A good support system. Because you saw how his sister turned out. He should have known better. But he continued to pull that trigger over and over and over again. And he knew it was in his heart. It was to hurt or kill somebody. And because of that, he left a 13-year-old child dead on the hot summer pavement as his mother screamed out over him to breathe, Malik. Breathe. He is not our victim. He is not your victim. Because on June 4th, 2019, it's one of the happiest days of a kid's year. First day of summer, right? You saw the kids. You saw how the kids were playing in the store, laughing. They just got done playing football. Not a care in the world. Not a care in the world. That within 10 minutes, he'd be laying on the hot pavement floor in front of his apartment, begging for his mom, telling his best friends that his back was burning from the bullet that this man placed in his back, tearing through his skin as he dropped his snacks, as Michael Dukes ran up and tried to save him. Calling 911, you heard his mother. That is supposed to be a child's best day. First day of summer. There will be no more first days of summer. There will be no more trick-or-treating, no learning to drive, no proms. No children. Malik's bloodline stops in front of the Silver Car hotel, or apartment complex at the hands of this man. That's where his bloodline stops. There will be no visits. His mom will come to see him, but a headstone. His family will come and see him. His sister will continue to visit him. His grandmother will continue to visit him. That was supposed to be a happy day. And you heard from Mr. White. This is a day that will remain in all of these individuals' heads. The officers who did everything they could. We went from 7:03 p.m. to 8:30 p.m. and the doctor's announcing him dead. And don't you know that every single person involved did everything they could to give Malik a chance at living, except for this man. Michael Dukes tried to give him a chance. The responding officers applying CPR and medical attention, the DFR, the emergency room doctors as they opened up his chest and tried to save him. They all tried to give him a chance. And who else was given a chance? Back in 2010, at 12 years old. Go back and read those priors. Those aren't just boxes that are just checked that says the defendant is in need of rehabilitation. The public is in need of protection. The defendant is in need of protection from himself. Don't you think Malik would have liked to know that back in 2010, a judge made an official order, and an order in the courtroom, saying that we are in need of protection from him. And here we are 11 years later, and he's killed a child. These are not just checked boxes, ladies and gentlemen. In fact, if you go through and look at what's in there, and look at what's checked, aggressive history towards others, negative association with peers. Those are not just boxes that are being checked by a judge. I assure you that, because they're in every single order year after year. And if you thought in 2010, after committing an evading arrest at 12 years old, after the juvenile system tried to help him, that he would change, you thought then, you would have been wrong. Because on 11/29/2011, the defendant commits a robbery. He's given even more assistance from our criminal justice system, from the probation department. And if you thought then, at 14 years old, that Datrell Dion Clayton was going to change, you would have been wrong. And what about at 15? What about on February 2nd, 2013? Burglary of a habitation, theft, evading arrest. What about after these 3 chances? If you thought then that he was going to change, you would have been wrong. And now he becomes an adult in 2015. He's arrested and charged with aggravated assault with a deadly weapon, a firearm. And while he's in jail, what did you hear? What did you hear about while he was in jail? Fighting. Fighting in the jail. He bonds out. You would think then he's going to change, because now he's looking at up to 20 years in prison. Now the defendant's going to change, but then you would have been wrong again, because on August 29th of 2016, at 19 years old, he shoots 2 people. Aggravated assault with a deadly weapon.
2 minutes remaining.
Thank you, Your Honor. And if you thought then that he was going to change, you would have been wrong, because what you know from the testimony yesterday is that he gets back into the jail, he continues to threaten guards. He is the bully. He is a super savage, as he has tattooed on his arms. And his grandmother said something very, very important yesterday. Watch the video. He was just acting on his instincts. Just remember this. What was everybody else's instinct? And what was his instinct? I can go through all the gang stuff and all the detectives. I think it's very evident that Detective Howard, who has no involvement with this defendant, has pretty much summed it up to you that he was a member of the Lion Beef stretch gang here in Dallas that had a 3-year ongoing beef. And because of that, that's probably why he was shot. But he is not the victim. when you go back and you deliberate, and you take into consideration what the defense said, that a life sentence is intended for those who commit the worst of the worst. Those that wake up and go out and victimize our community. In 24 years of life, what has he done? From multiple gun charges, to robberies, to breaking into houses, to promoting an ongoing gang feud within our city. And what did he get tattooed on himself when he got out of jail?
Wrap it up, Mr. Adams.
Thank you. And at the very end of this, he took a child's life, the worst of the worst. And that is why, in this case, the only just sentence is a sentence of life.
Thank you. All right, jurors, we will now dismiss you all to deliberate. You will have the charge. I'll give you that pad of paper that you had before. And alternates, we will still have you all separated in the next jury room. Court is in recess until we have a number on punishment. Okay. For the record, the jury has been brought back into court, and we will now read the verdict. Mr. Johnson, let me have you and your client stand, please. Verdict form on punishment. We, the jury, having found defendant Datrell Dion Clayton guilty of murder, and further having found the allegations set out in the enhancing paragraph is true, assess the defendant's punishment and imprisonment in the institutional division of the Texas Department of Criminal Justice, a term of life, and a fine of $10,000, signed by the presiding juror, and the presiding juror's name is printed. All right, counsel, you may have a seat. That concludes the case for Datrell Dion Clayton. Jurors, I want to thank you from the bottom of my heart for this very difficult job you had to do. Thank you for your time and attention. And in just a few minutes, if you all will retire to the jury room, I'm going to come back and just have a few words with you. Court is in recess.
All rise.